Cassandra, is this, what component of a court case is this?
I think it's court's application of rule to key facts.
You got it. Yes. Okay, great. All right. That is what it is. Okay. And then let's see. Do you Cassandra, do you remember what the facts were in this case? This was about what? I mean, it's about symbolic speech, yes, but it was about burning something. Do you remember?
The burning of a flag, right? I think.
Okay, well that was, we're going to talk about that one next. But what was the case that came before that one? Another one involving burning what?
Burning. I'm sorry. Let me look for it.
A certain. Okay, yeah. Yeah, we should look and see. Look at my textbook here. What's my?
Oh, burning of the draft cards, I think.
Yeah, burning the draft cards. Yeah. All right, and so we're let's see here on page, I believe, yeah, page 205, 205. All right. Yeah, we perceive. Okay. Moving on here, burning draft cards. Okay, so and so what's the outcome in this case? Carla. All right, yeah. So Congress's 1965 amendment to the Selective Service Act of 1948 violated or did not violate the First Amendment when the amendment bans the burning of draft cards as symbolic speech.
It did violate.
Are you sure about that? All right, yeah, let me just go back here, the interweaving here, okay? So they're saying that they're agreeing that there's no alternative means. Okay, let's look here. All right, so this is in the way. So, oh gosh, all right. I don't think we're gonna need that. Okay, so you see here we've got this regulation here, this rule, right? This court's rule, and in this case, and saying that, okay, well, it's constitutional. Power of government. Also, it says here that there's these four or like 5 prongs. 1, 2, 3, 4, 5. I think, yeah. 1, 2, 3. Yeah, 4 prongs actually. Okay, and so they're saying there's an alternative means. So this prong is meant here that then if the incidental restriction is no greater than is essential, so there isn't something that can address this governmental interest in a way that's less alternative means it's more precisely doesn't inherently goes after the interest, addresses the interest. All right. Also, it prohibits such conduct and nothing more. Okay. And again, it's really, it's really going after the no greater than essential. All this really goes to meeting this 4th prong here. All right. So if the 4th prong is met and all these other prongs are met, then when looking at this ban that says, hey, we're gonna ban your behavior. Not your speech, but ban your behavior, your conduct, in other words. Again, the amendment only goes after the conduct and nothing more. All right. So when this speech goes only after the conduct and nothing more, there's alternative means, then does this amendment to the Selective Service Act violate or not violate the First Amendment?
Not violate.
It does not violate. That's right. Okay, good. Yes. All right. New case. Okay. So Cassandra. All right. What are the are there any facts particular to the case, and then are there any standards? Okay. While the Republican Party was meeting for its national convention, a group of 75 to 100 demonstrators marched into the city to protest the Reagan administration's policies. As the march ended, Johnson unfurled the American flag, doused it with kerosene, and lit it on fire. Set it on fire, and it burned. And the protesters chanted, "America, the red, white, and blue, we spit on you." Authorities arrested Johnson, charging him with violating the Texas flag desecration law. He was convicted and sentenced to a 1-year prison term and a fine of $2,000. That's pretty steep, right? And so do we have any facts particular to this case?
Yes, and I don't think I see standards.
That's right. You got it. Okay. All right. And so do we have here interweaving or narration of injury?
Narration of injury.
And what component of a court case is this?
Challenge governmental act.
That's right. Okay, you got it. Okay, excellent. All right, Carla. Okay, what constitutional section is the court interpreting in this case?
Symbolic.
Involving symbolic speech. So it's what?
The Fifth Amendment. No, the first.
First Amendment. What a clause in the First Amendment?
Free speech.
You got it. All right. Yes, freedom of speech. Okay, and it involves Texas, a state, and not the federal government. Okay, so what other clause is being interpreted? Because it's applying freedom of speech clause to the states, a state. So what clause?
Due process.
Yes, of what amendment? Not the fifth, but which clause has the equal protection clause and the due process clause, both? That was enacted around after Civil War during Reconstruction.
The 14th.
Yes. Okay, good. Yes. All right, great. And so help me with a general question here, Carla. Okay, so here we have through its incorporation, again, it's incorporated into what clause? Yeah, it's incorporated and applies to states through what clause?
The due process.
Yeah, right. Yeah, the 14th Amendment. All right, and is the again what is incorporated into the due process clause? What clause is incorporated into the due process clause? The part of the fundamental provision in the Bill of Rights. It's in the constitutional section here. What clause? So it's one of these.
The freedom of speech.
Yeah, the freedom of speech clause. Okay, yes. All right. Other First Amendment is violated when what? When a state statute does what?
Violates it.
Yeah, when a state statute does what? When it prohibits what? What did Johnson do? What did he do to the flag?
He burned it.
Yeah, or desecrated it. Yeah. All right. Yeah. Okay, good. And again, what type of speech is this? Starting with an S?
Symbolic speech.
Yeah, good. Yeah. Yeah, when a state law penalizes the burning of the American flag. Okay. All right. Now, great. Now back to Cassandra. Okay. So in deciding whether particular conduct possesses sufficient communicative elements to bring the First Amendment into play, we have answered whether an intent to convey a particularized message was present and whether the likelihood was great that the message, okay, would be understood by those who viewed it. All right. So what do you think? Do we have facts particularly the case? Or any legal standards here in this excerpt?
I don't see facts. I see standards.
That's right. Excellent. Yes. All right. Some of the standards.
Sorry. The standards, the intent to convey and would be understood.
Yeah, I mean, I think, yeah, intent to convey, yes. Right, will be understood by those who viewed it. Yes, okay, that's getting towards, yeah, the standards there. Okay, good, yes. All right. So I guess, so this is basically a what? What, Cassandra, what part of a court case is this?
Uh, I think it's a rationale, so method of interpretation.
Nope, sorry, it's not.
Oh. Um, okay, so court's rule in this case?
That's right. Yes. Yeah, because we have no facts particular in this case, and we have standards. Okay. All right. Yeah, and court's interpretation, would, I mean, method of interpretation would not have standards. All right. Yeah. So it's basically saying this is the court's rule for determining, whether behavior, conduct, all right, is actually communicating, is actually symbolic speech.
Can I ask a question before
Yes,
we move
please.
on? What's the difference between a rationale and the court's rule in this case?
Okay, good question. Yeah, so the rationale is not going to have facts particular case, all right, but it's not going to have standards. Instead, it will have, rationale, for why the court is interpreting the Constitution a certain way.
Oh, okay. All right.
Is that helpful?
Yeah, yeah.
Yeah, I
So
mean,
no facts, no standards.
yeah. In other words, once we identified standards, then you want to move away from court's interpretation.
Okay.
Or method of interpretation. All right, yeah, okay. So here we do have court's rule, and this is the rule for about determining whether conduct is sufficiently communicative. All right, and it is, when we have two prongs met. First, there's an intent to convey a particularized message, and also whether there is the likelihood that the message will be understood. All right, by those who viewed it. All right, and so let's see, if what's next here. All right, so Carla, while I read this, think about, do we have any facts particular to this case, and do we have any standards? Johnson burned the American flag as part, indeed, as a culmination of a political demonstration that coincided with the convening of the Republican Party and its renomination of Ronald Reagan for president. In these circumstances, Johnson's burning of the flag was conduct sufficiently imbued with elements of communication to implicate the First Amendment. All right. Do we have any facts particular to this case, Carla?
I see facts, but no standards.
Are you sure?
No.
I mean, do you see anything, from here, that would, there's an intent to convey a message, anything like that? You see anything like that here? That you had a conduct.
Yes.
Yeah, what? I mean, you see, you have conduct, intent to convey, with intent to convey.
Yes,
So, so what words?
intent to convey.
Well, no, what words here, do we see? It's in the last sentence.
Elements of communication.
All right, yeah, and the conduct, had these elements of, sufficiently these elements of communication. All right, good. So what do we have here, interweaving or narration of injury?
Interweaving.
That's right. And Carla, what is interweaving?
Court's rule application.
Okay, yes, it is. Okay, it is right. But also, I mean, when you look at interweaving, what is it?
Oh, it's mix. It's a mix of standards and facts.
Yeah, that's true. That's one way to look at it. And it's an argument about whether the facts what?
Was intentional?
No, whether the facts rise to the level of doing what to the standards?
Violated the standards?
No, not violate. I mean, they're arguing here that, hey, it rose to the level of being conduct, sufficiently imbued with elements of communication. And so they're saying that what was that the facts, what the standards, starting with an M.
Meet.
Yeah, you got it. All right, good. All right, good. And as you said correctly, okay, this is the course application of the rule of the key facts. All right. Okay, back to Cassandra. All right. If this, think about, do we have any facts, particular case? Do we have any standards? If the state's regulation is not related to expression, then the less stringent standard we announced in United States versus O'Brien for regulations of non-communicative conduct controls. But if it is, then we are outside of the O'Brien test. The O'Brien test will not be applied. All right, do we have any facts particular to this case?
Not this case, but a past case. So no.
No. Are they really talking specifically here, or more like generally? When it says states regulation.
Oh, I was talking more about the United States versus O'Brien.
Oh, right. Yeah. I mean, it certainly is, mentioning another prior case, but I think it's talking more about what in the prior case.
The state.
Well, what is it talking about? A particular state? It says the state's regulation. If the state's regulation is not related to the expression.
Oh, no, it's a general.
All right. So there's no facts particular to the case. And are there any legal standards?
Yes.
Yes. Where?
State regulation is not related to expression, and then outside of O'Brien's test.
Yeah. All right. Yeah. So that's the result. If, yeah. So basically it's citing O'Brien in order to have this test, here, this is part of the one of the 4 prongs from the O'Brien test that's not related, to expression. All right. All right. And, it doesn't affect that expression. All right. Excellent. Okay. So do we, so next, so what type of component of a court case is this?
It's court's rule in this case.
That's right. Excellent. Yeah, it's court's rule on which test to be used. Okay, so it's about a rule about which rule to use. All right. Now, back to Carla. Okay, if there is a bedrock principle underlying the First Amendment, it is that government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. All right. Do we have any facts particular to this case?
No.
You're right. Do we have any legal standards?
Yes.
Are you sure? I mean, or, is this a rationale?
Well, it says the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable.
Yeah, but it has the word because in there. So what does that tell you?
So no, it's a rationale.
Yeah, it is a rationale. Okay, good. All right. Well, actually, all right. You could take it that way. But actually, what is it? All right. So they're saying here there's standards. Okay. So if these are all standards, then what is this? Because actually, you're right. It's basically the laying down the law saying government may not prohibit expression of an idea simply because society finds it offensive or disagreeable. So if it's really not a rationale, then what is it?
Court's rule in this case. Oh, method of
interpretation. Right. Yeah, it's court's rule in this case. Okay, good. Yeah. All right. Yeah. No, I was just focusing on the because. Okay. But actually, it's really saying simply because. And reading it that way, it is like a rule. Got it? See the difference between saying this is why we're doing it versus we can't do it just because, simply because they find it offensive. You see the difference between because and simply because?
Yes.
Yeah, and because it's saying simply because, it really is a rule. Okay, good. All right, great. Okay, now the state offers 2 separate interests. All right, this is Cassandra. To justify this conviction. Okay, first it says, oh, we need to prevent breaches of the peace. And also we need to preserve the flag as a symbol of nationhood and national unity. We should hold the first interest We hold that the first interest is not implicated, on this record, and that the second is related to the suppression of expression. All right. So Cassandra, right, you're next. So do you have any facts particular to this case in this excerpt? Yes or no?
Yes.
Yeah, when it says the state offers two separate interests, is that talking about Texas in particular or the state in general?
Texas.
Yeah, right. And do we have any legal standards?
Yes. Preventing breaches of the peace and preserving the flag as a symbol.
No, no. But another word is sort of key, really key here, starting with an I.
Implicated.
No, I-N.
IN. Oh,
I-N.
interest.
Yeah, an interest. Yeah. All right. So here, the state is trying to provide an argument for why they have an interest, that could justify, their conviction. All right. And also part of it says when it says interest is related to suppression of free speech. All right. Does that sound like that rule that outlaws the desecration of the flag? Is that rule going to be, is that statute going to be constitutional or not when it says that this interest is related to the suppression of expression?
Can you repeat the question? Sorry.
Yeah. I mean, if the statute, that bans the desecration of the flag, if that interest behind that statute is related to shutting up speech, then is that statute likely to be constitutional or unconstitutional?
Unconstitutional.
That's right. Okay, good. And so do we have interweaving here or do we have narration of injury?
Interweaving.
That's right. Yeah, again, what's interweaving?
When the facts meet the standards.
Yep. Okay, good. An argument about that. All right. Yeah. And what component of a court case do we have here?
Court's application of rule to key facts.
That's right. Okay, good. That's excellent. Okay, good. All right. Excellent. All right. Now another one here. Okay, back to Carla. So the state is concerned that such conduct will lead people to believe either that the flag does not stand for nationhood and national unity, but instead reflects other less positive concepts, or that the concepts reflected in the flag do not, in fact, exist. That is, we do not enjoy unity as a nation. These concerns blossom only when a person's treatment of the flag communicates some message, and thus are related to the suppression of free expression within the meaning of the O'Brien. We are thus outside of O'Brien's test altogether. So do we have facts particular in this case? Carla.
No.
When it says the state is concerned that such conduct will lead people to believe that the flag, blah, 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 is that talking about the state of Texas or is that talking about states in general?
The state in general.
Are you sure?
Texas.
Or this Texas putting forth this argument? We need this statute because it promotes this interest of unity. So do we have any facts in this case?
No.
Are you sure? It says the state is concerned. When you say that, when it says the state is concerned, is that talking about Texas in particular or the state in general?
I mean, yes, and Texas.
All right, it talks about Texas, right? And do we have facts particular to this case?
Yes.
Yeah, because we're talking about Texas and specifically. Do we have any legal standards?
No.
We do. Sorry. Where are they? Again, and these standards are similar to the ones we found here. What are those standards about interest and interest related to the suppression of expression? We've seen any of that here? Like towards the end, maybe?
Oh, yes, are related.
Right, to what?
To the suppression of free expression.
All right, good. Yes. And so what do we have here? Interweaving or narration of injury?
Interweaving.
That's right. And so, and what do you think? In this interweaving, do the facts rise to the level of being speech that's related to the suppression of free expression? I mean, do these facts communicate a message that is related to the suppression of free speech?
Yes.
All right. Yes. Yeah. So yeah, we have
Yeah.
here facts that are related to shutting up speech. All right. Excellent. Okay. Good. And so we have application of the rule, the key facts. That's what we have here. And so Cassandra, what is? All right. Actually, we had one more. We have this. So do we have facts particular in this case, and do we have standards? The state's interest in preventing breaches of the peace does not support his conviction because Johnson's conduct did not threaten, excuse me, it did not, oops, what do we got here? Yeah. Yeah. So it did not threaten to disturb the peace. So do we have here any facts particular in this case?
Yes, it's talking about Texas and
Yeah.
then Johnson's.
Johnson's conduct, right? And so do we have here also any standards?
I think so because it says does not support his conviction and did not disturb the peace.
Well, actually, it's more about whether the state's interest, really can rationalize the conviction. All right, so standard is interest is the standard here. Okay. All right, and so we do have application of the rule of the key facts here. And all right, Carla. Now, well, actually, Cassandra, I'm going to keep with you because that was
Okay.
easy. So, Cassandra. So what's the answer here? That the First Amendment is violated or is not violated when a state law penalizes the burning of the American flag?
Uh, is is violated.
That's correct. Excellent. Any questions about that? Got that? All right, new case. All right, back to Carla. On April 6th, we have a fact particular case. Do we have any standards? Jehovah's Witnesses member Walter Chaplinsky was selling religious pamphlets and literature on a public street, public forum in New Hampshire. Several took offense at Chaplinsky's comments about organized religion and racketeer priests and complained to the city of Marshall. The marshal warned Chaplinsky that the people were getting into an ugly mood, but Chaplinsky continued to express his religious views and distribute his literature. After one person tried to attack Chaplinsky, the marshal and three of his men intervened and forcibly began to take Chaplinsky to City Hall. Do we have facts particular to the case? Carla?
Yes.
Yes. Do we have any legal standards?
Well, it says he was selling religious pamphlets and literature on a public street, but it's not a legal
Is
standard.
this like more like an argument or more like a narration of what happened?
Oh, narration.
Yeah. Okay. Good. Yeah. So this is a narration, right? And so, what component of a court case is this?
Court rule of application?
No. Again, we have narration here, narration of injury. All right, and we only have facts.
Oh, it's challenge government to that.
That's right. Okay. Good. Yes. Okay. Good. All right. And then back to you, Cassandra. When a very agitated Chaplinsky demanded to know why they had arrested him and not those in the crowd, one of the officers replied, "Shut up, you damn bastard." And Chaplinsky in turn called the officer a damn fascist and a goddamn racketeer. For those words, the state charged him with breaking a law prohibiting the use of any offensive, derisive, or annoying word to any other person who is lawfully in the street. Chaplinsky was convicted and received a fine. So, what do you think? Do we have any facts particular case, Cassandra? Yeah.
Yes, facts. I don't see standards.
That's right. That's right. So what do we have here? Do we have an interweaving or a narration of injury?
I think it's another narration.
Okay, good. And you are right. Excellent. And also, do we have any okay, so what component of a court case is this?
Challenge governmental act.
That's right. Perfect. All right. And okay, back to Carla. Carla, so actually you did this last time, so I'm gonna keep with Cassandra. So Cassandra, what constitutional section is this court interpreting?
The freedom of speech.
Yes. Clause of the
First Amendment.
yes, and
And the due process clause of the 14th Amendment.
yeah, why is it interpreting the due process clause, the 14th Amendment?
Thinking.
Okay.
Oh, because he was processed under the law for violating freedom of speech.
Because does the freedom of speech clause applying here in this case to a state or to the federal government?
To the state in particular.
Yeah. All right. In order to make sure that the First Amendment freedom of speech clause is incorporated into what clause? Then it applies to states.
Into the one I already said before, the 14th Amendment, the due process.
Yeah, due process clause. Okay, you got it. Okay, good. All right. Now, here's a general question based on the what? What do you have to have here? Okay, based on what clause might have been violated?
The First Amendment, freedom of speech clause.
Okay, good. Yes. And it's what? And how does it apply to states? Because of the
due process clause of the 14th Amendment.
Right, because the freedom of speech clause is incorporated, all right, into the 14th Amendment due process clause, 14th Amendment due process clause. And then can a state law constitutionally do what? I mean, again, when writing these issues, you're going to find that you really need to go through the whole case, and you can't really base it just on the facts that we know, the Challenge Governmental Act. But how was Chaplinsky directing his speech? Was it to a particular person?
Yes, it was particular to a person, and it was kind of harassment.
Okay, yeah. Do you think it was speech directed at a person that was likely to move that person to violence or a fight?
Yes.
Yeah.
Aggressive words.
Right, exactly, yeah. And then, and so the rest of this is, can a state law constitutionally punish what's called face-to-face fighting words, okay, directed at an individual? All right, so Carla, have you ever heard of the term fighting words?
Yes.
Yes? Where?
Homework.
In what context? Or have you heard it just from me?
From the homework.
All right, from the homework, yeah. All right, that's where you first saw it, yeah?
I heard it in my communication class.
Oh, yeah, okay. All right, and are there any type of particular movies? This is to Cassandra or Carla. Are there any particular movies where you might be more likely to hear that phrase? Them.
I think it was, yeah, that phrase. Those are fighting words.
Yeah.
I can't remember which movie. But,
Oh,
yeah.
yeah. But what particular type of movie?
Rambo?
What's that?
Rambo?
Okay, I don't know if it's Rambo. It's been too long since I've seen Rambo. Okay. All right, baby. All right, them are fighting words. Okay, that sounds like someone who is in what type of movie?
An action movie or crime movie.
Or let's say they're in a bar, and everyone's really tense, and and let's say it's a saloon. We're talking about what type of movie?
Western.
Okay, yeah. All right. What we got here? Okay, so Cassandra, So are there any facts particular to this case? All right. And are there any standards? It has been well observed that such utterances are no essential part of any exposition of ideas and are of such slight social value as a step to the truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. All right. So, Cassandra, do we have here legal standards or a rationale for constitutional interpretation?
It sounds like a rationale.
Okay, yeah. All right, it is. And then what constitutional method is being used? What method of interpretation?
Method of interpretation.
Yeah, what method of interpretation is being used here? That we have to have an interpretation that recognizes that these words are of slight social value in relation to law and order and morality. So which method is concerned about the results of your interpretation, the consequences of your interpretation?
Oh, okay. Pragmatism.
Yeah, that's right. All right, excellent. Yes. All right. And moving to Carla. Carla, what do you think? Were Chaplinsky's words merely fighting words with slight social value? What do you think?
Yes.
Were they of slight value? All right, I'll ask you another question. All right. I mean, was he Chaplinsky? Was he when he said, to the officials, you're a racketeer? Was he making some social commentary about government?
Yes.
Yeah, and if that's the case, are they merely words with slight social value?
No.
No. Right? Yeah, you got it. Yes. Okay. I have to go to the next set of PowerPoint slides. All right. Yeah. And so, yeah, because he was commenting on the conduct of government officials. Yes. All right. Great. All right. Carla, now this is again with you. So the test is what men of common intelligence would understand would be words likely to cause an average addressee to fight as a response. Okay, so Carla, do we have any facts particular to this case? Yes or no?
No facts.
No facts particular to this case. Do we have any legal standards?
No legal standards.
Are you sure about that? Does this rise the level of being likely to cause an average person to fight? What about those words?
So yes.
What do you think those are standards?
No.
Are you sure? It
I don't.
has the word test here, so when there's a test or saying this is a test, then does that mean that there are standards in that follow that are part of a test that must be met?
The test is what men have common sense. So yes.
Yes, it is a test, and are there legal standards as part of this test?
Maybe. Yes.
Yes or no? Don't maybe me.
Yes.
Yeah, there are standards, right? Where are the standards? I told you where they are. Where are they?
Words would likely to cause a fight.
Yeah, the addressee to fight. All right, you got it. Okay, good. All right, and what component of a court case is this? All right, again, you don't have any facts, particularly the case, but you do have standards. Then that means it's what component of a court case?
Court's rule in this case?
Yes, that's right. Okay, good. All right. Okay, excellent. Back to Cassandra. Okay, next one is for you. Do we have facts, particular case? Do we have any legal standards? Derisive and annoying words can be taken as coming within the purview of the statute as heretofore interpreted only when they have this characteristic of plainly tending to excite the addressee to a breach of the peace. So, do we have any facts particular to this case? For example, when it says within the purview of the statute, as heretofore interpreted, are they talking about the statute in this case, or are they talking about statutes in general?
The statute of that case.
That's right. So do we have facts particular to this case?
Yes, but
And
it's very subtle.
it is subtle, you're right. All right, that's why I was helping you out there. What about, are there any legal standards?
Yes.
All right, where are they?
When it's like characterizing the characteristic of plainly tending to excite the addressee.
Yeah, right. The annoying and derisive words really must, if they are going to be within the purview of that statute, must, be plainly tending to excite the addressee to a breach of peace. Oh, you got it. All right, excellent. All right, and so is this interweaving or narration of injury?
Interweaving.
That's right. And again, what is interweaving?
When the facts meet the standards.
Right. An argument about that. And so what component of a court case do we have here?
Court's application of rule to key facts.
Perfect. Okay, good. All right. So back to Carla. Again, do we have any facts particular in this case? Do we have any legal standards? The statute as construed does no more than prohibit the face-to-face words plainly likely to cause a breach of the peace by the addressee, words whose meaning constitutes a breach of the peace by the speaker, including classical fighting words, words in current use, less classical, but equally likely to cause violence, and other disorderly words, including profanity, obscenity, and threats. Argument is unnecessary to demonstrate that the appellations damn racketeer and damn fascist are epithets likely to provoke the average person to retaliation and thereby cause a breach of the peace. Do we have any facts particular to this case?
It sounds more like a Russian now.
Are you sure? I mean, it says damn racketeer, damn fascist. Are those facts that were stated by Chaplinsky?
Yes.
Yes. Do we have any facts particular to this case then?
Yes.
And do we have any legal standards? I mean, are they arguing here that the words damn racketeer and damn fascist rise to the level of what?
To retaliation?
Yes, right?
Yes.
Yeah, to
So
provoke
that's
the average person to
legal
retaliate.
stand.
So is that standards? Do we have standards, legal standards?
Yes.
We do. Okay, good. So is this interweaving or narration of the injury?
Interweaving.
Right. And again, what is interweaving?
Is cultural application?
Okay. Well, all right, yes. Yeah, it is the application of the rule to the key facts. And again, interweaving is an argument that what? Interweaving is an argument that the
Challenge government.
no.
Mm.
I mean, yeah, I mean, if you have your sheet, I think, that it really defines what interweaving is there. It's a,
Where is it? Oh, I found it.
okay.
Court's application of rule to key facts.
No. We already established that. You gave that to me. Okay. But what is interweaving? It's an argument that the what?
That implies?
No, an argument that, well, I mean, that what? We're not talking about the word imply, but we're talking about the what, starting with an F. The what in the case? F, F-A.
Oh, facts.
Yeah, in this case. Excellent. Okay. And do what with the standards?
They meet the standards.
That's right. Correct. Okay, excellent. All right. And so, as you said, this is the court's application of the rules of key facts. All right. And then, okay. So back to Cassandra. All right. So what's the answer here? Based on the freedom of speech clause of the First Amendment and is incorporation into the 14th Amendment's due process clause, a state law can or cannot constitutionally punish face-to-face fighting words directed at an individual.
They can.
That's right. Excellent. Great job. Okay, good. Another case here, all right, is about offensive speech. All right. And so back to Carla. Do we have any facts particular to this case? And do we have any standards? All right. So while discussing their opposition to the war, the Vietnam War, someone scrawled on Cohen's jacket the words, "fuck the draft." All right. And "stop the war." Cohen wore his jacket in the corridors of a Los Angeles County courthouse where men, women, and children were present, knowing it bore these messages. Although Cohen took off the jacket before entering the courtroom, a police sergeant had observed it in the corridor. The officer asked the judge to cite Cohen for contempt of court. So do we have a fact particular in this case? We're Carla, right?
Yes, we have facts.
Yes. And do we have legal standards here?
Yes, we do.
Are you sure?
I mean, no standards.
No standards. Okay, yeah, because I don't see any here. All right, great, excellent. Okay, back to okay. Well, actually, Carla, back to you. So what do we have here? Do we have interweaving with an answer? Or do we have narration?
Narration.
We do.
Of injury.
The injury of yes, narration of the injury. All right. And so, what component of a court case is this?
Challenge governmental action.
Perfect. Okay, good. All right. And okay, now back to Cassandra. All right, there's a little bit of here, Cassandra, that the judge refused, but the officer arrested Cohen, charging him with willfully and unlawfully and maliciously disturbing the peace and quiet by engaging in tumultuous and offensive conduct. All right. So do we have any okay, what constitutional section is being interpreted here? Cassandra.
Freedom of speech, First Amendment,
Yes. Okay. Yes. And what else?
and the 14th due process.
Yes. Why the 14th Amendment is being interpreted here? Why is it?
Because, I mean, they're talking about the legal system and being processed through it.
We talked about this. Because what type of government are we is in this case?
Oh, California.
Right? Yeah,
Government.
government. And therefore, why do we have the 14th Amendment's due process clause? Because
For state government.
yeah, to make sure that what applies to state government. The what clause?
The First Amendment.
Yes, the First Amendment's freedom of speech clause. Okay, okay, all right, good. All right, and then stay with me. Okay, so Cassandra, this is a general question. Under the what? Again, what main clause is being interpreted here?
Freedom of speech.
Yeah, freedom of speech clause, the First Amendment, and it's what?
And it's
I-N.
interpretation.
No, I-N-C.
INC.
Oh.
INC.
I-N-C-O-R. You know, this is
Incorporation.
Incorporation. That's good. Yes, yes. Into the
14th due process clause.
perfect. All right. So, is a state law punishing what? What is being punished here? What type of speech? Starting with an O.
Oh.
It's in the Roman numeral 10. line there?
Oh, other types of speech.
Well, yeah, what type of speech in
Oh,
particular?
offensive speech.
Yeah, okay. Yeah, the state law punishing offensive speech. Okay, yeah, constitutional. That's basically the issue there. Constitutional when. All right, and so again, to write this issue, you really have to know all of the application of the rule to all these various facts. But what do you think? First off, was anyone like was anyone like offended or hurt? Do we have any facts going towards that or stating that someone was hurt?
Yeah. Yes, like offended, I think.
Well, all right, yeah, the officer was offended. You're right. That is true. Okay, but did anyone? Well, first of all, did anyone treat these words as if they were fighting words?
The officer did.
But what about the general public? I mean, he he was a law officer, so he didn't have to be moved to violence. Okay, but were there any members of the public, that can't arrest, and therefore are resort to violence? I mean, because again, you have to ask yourself, did the officer resort to violence?
No.
No. All right. Yeah. I mean, and did it look like he might resort to violence?
No.
No. Instead, he arrested this person. He used his prerogative, his privilege of being able to arrest, to shut this person down. All right. And so, what about members of the public? Were any members of the public? Do I have any facts showing the members of the public wanted to fight or were moved to fight because of what he said?
I don't think so.
No, right? Yeah. All right. So yeah. So can a state law punishing offensive speech be constitutional when no one objected or reacted violently to the words on the appellant's jacket, and no one could reasonably have regarded the speech to have a direct personal insult? Okay, so it wasn't really directed at a person, right? I mean,
Oh, was it?
no, yeah. I mean, it was just it was a speech on a jacket. It wasn't directed to the officer or any particular member of the public. All right, excellent. So that's our issue here or question. All right, now, Carla. Okay, so a statute must fail, all right, in the absence of any language in the statute that would have put a person on notice that would put a person on notice that certain kinds of otherwise permissible speech or conduct would nonetheless not be tolerated in certain places. Again, so a statute must fail in the absence of any language that would put someone on notice that certain types of speech or conduct would not be tolerated in a certain place or places. So do we have any facts particular to this case in this excerpt? Carla?
Mm,
You see anything about the parties, Cohen, California, the state?
no facts.
No facts. Yeah, when it says a person, is it talking about a person in particular or a person in general? In the context of that excerpt, is it talking about a person general or a person?
General.
General. Okay, good. So we don't have any facts particular to this case. Do we have any legal standards here? Is basically is this rule? Do we have here laying down the line of when a statute must fail because it doesn't have any, when it has no language giving notice? So, when it's laying down the law or laying down, when a statute must fail, then does that sound like it has legal standards or not?
Yes, legal standards.
Okay, we do have legal standards. Okay, good. So what component of a court case is this?
Is it court's rule?
That's right. Perfect. Okay, good. All right, excellent. All right, court's rule in this case. Okay, now back to Cassandra. No fair reading of the phrase offensive conduct can be said sufficiently to inform the ordinary person that distinctions between certain locations are thereby created. Do any facts particular this case?
No.
Are you sure? When it says a phrase offensive conduct, is that is that phrase like a quote from the statute in this case?
Yeah, he's taking the quote from the previous thing.
Yeah,
Offensive
I mean,
conduct.
it's a quote from the statute that's at issue in this case. All right, so do we have any facts particular in this case?
Yes.
Yes. Do we have any legal standards?
Mm,
I mean, are there any like legal standards that you can see from here? About notice, things like that. You see anything of that here? What's a word is like notice? It starts with an I.
inform?
And form. Okay. So do we have any legal standards here?
Yes.
Okay, good. And what are they?
Inform the ordinary person.
Yeah. Yeah, that's distinctions between certain locations are thereby created. All right, great. And so do we have here interweaving or injury narration?
Interweaving.
Right. Okay. Again, what is interweaving?
When facts meet the standards.
Yes. Okay, good. All right, good. Yeah, an argument about whether the facts meet the standards. Okay, good. And what component of a court case do we have here?
Court's application of rule to key facts.
Perfect. Okay, good. All right. And what do you think? Since there isn't sufficient notice, no fair reading can say that there's sufficient notice to inform the ordinary person, that certain locations, the distinctions between, to make distinctions between certain locations, there's just not sufficiently informing the ordinary person. Does that mean that the statute is impermissibly vague or not?
I think it's kind of broad.
Yeah, it's broad. I mean, when it's not giving notice, then is it by definition vague?
Yes.
Yes, it's not telling that person, making that person notice it. Oh, in these certain locations, what you're gonna say is gonna be punished. All right, no, it's not giving that. Okay. All right, so this is vague. All right, now back to Carla. Okay, the states are free, all right, to ban the simple use without a demonstration of the additional justifying circumstances, all right, of so-called fighting words, okay? Those personally abusive epithets, which when addressed to the ordinary citizens are, as a matter of common knowledge, inherently likely to provoke violent reaction. All right. So, Carla, do we have any facts particular in this case?
Yes.
Well, when it says states are free, the states are free. It's talking about a particular case or the states in general?
The states in general.
That's right. Okay. And do we have any legal standards?
Yes.
We do. Where are they?
Those personally abusive epithets, which when addressed to the ordinary citizens.
Right. Yeah. Inherently likely to provoke a violent reaction. Okay. So what component of a court case is this?
Court's rule?
That's right. All right. Excellent. All right. We got to go. All right. But I want to ask you a question. All right. Is it possible, do you consent, both of you, to having me put this on Instagram, where the public can see it, or on YouTube? Do you consent to that, or is it just too personal and you'd rather not? It's your choice. I can go either way. Cassandra, what do you think?
I don't really care. That's fine.
All right. Carla, is this okay?
Yes, it's fine.
All right. Yeah. I mean, I like to be able to show people what I do here in class, and since there's just two of you, okay, I gotta let you go. Great job.
All right.